I would like to introduce and welcome Advocate Ashish Sharma ji. He is managing partner of the IP Nation, the law firm, and he is a registered patent consultant and IP attorney for startup of the Government of India. Dr. Sharma is IP attorney, Global IPR Law Consultancy, New Delhi, India, and he is Secretary General, IP Owner Association in India. Advocate Ashish Sharma, having professional experience of around 15 years, he is a registered patent consultant and IP facilitator for startups, intellectual property rights. He has appeared in number of cases before Controller of Patents, before Intellectual Property Appellate Board, IPAB, and before Indian courts. His major responsibility includes coordination with the all national and international university and scholar clients. He also handles licensing, IP enforcement, assignments, contract, and litigation matter pertaining to the various intellectual property rights. He has been regular invitee as expert lecturer and speaker on IP related subjects in various organizations, universities and institutions, including the law schools, management schools, R&D institution, corporate at various departments. We welcome Advocate Ashish Sharma ji for his valuable time. We are also thankful to him. We having Professor Dr. Bindra with us. He is Director Academics of the RIMT University, Punjab. Due to some technical glitches, he will be online and he is available with us with his blessings. But due to technical glitches, he having problem with his voice. Also, we welcome and thankful to the Dr. Bhatia ji, Pro Vice Chancellor of the RIMT University, for his valuable guidance and blessings. Now, over to Advocate Ashish Sharma ji.
Thank you. आप सभी का बहुत बहुत धन्यवाद. Thanks to all of you for RIMT team, and especially thanks to Dr. Suresh Kaswa ji, Dr. MS Bindra sir. Especially thanks to all your team to make this efforts to success this event. And so first of all, I would like to start my presentations. And here we will discuss about intellectual property rights and what the issues faced by the academic institution at the time of technology transfer and commercialization of any IPR rights. So first of all, we have to know regarding what is IPR and what types of IPR can be found by the academic institution in which forms. So let me start. So please start my presentation, Dr. Kaswa. So first of all, we have to know that what is intellectual property rights and what is patent, what is the difference between patent and copyright, because it is sometimes there is also confusion between what is patent and what is copyright and what is other IP rights. Like intellectual property is a property which is intangible property and which is relates to the creation of mind, which is creation of mind is the call of intangible property, which is called intellectual property. It may be like an expressions, an invention, expressions of literary collections, unique name, trade name, industrial designs as they appeals to the eye, new plant varieties, cinematographic, dramatic performance, musical works. So here we will discuss regarding patents, and here we will discuss regarding the difference between the patents and other rights. So what is the intelligence? Everybody has an intelligence, but what is intelligence? Because it's not because you think you know. It must be created by how, when, what, however. So you can heard the necessity is the mother of invention. So every time it is called necessity is the mother of invention. Next, please. So first of all, you must be thinking, self-interrogation. Ask yourself how, why, what, when, where. So these questions should be come in the mind at the time of invention or innovations. then it will create the creation of idea or it will creation of mind. So what is protection of intellectual property right? Conceptualizations, explanations, adaptations, and implementation, industrializations, marketing, selling, economic returns. Since the conceptualization of any innovations and till the commercialization, conceptualization to the commercialization, it is the process of it is the journey of any invention. Next, please. Next, please. Yes. So, what should I apply for a patent? What is the direct effect? It grants to your property rights like other property, and it gives you monopoly, and it protects your developments. It protects your R&D investment and economic benefits to the direct applicant and inventor. And what is indirect benefit? Convince your investor or partners to who invest his fund in your invention, protects from competitors, gives your identity, strengthens your position. So these are direct or indirect benefits by the innovations. So you can see the next slide, please. The next slide, please. Yes, you can see here the one product is called mobile phone. So the trademark name is Nokia and product name is 208 startup tone. So these features will be covered under trademark. And what will be covered under copyright? You can easily distinguish the aspects of intellectual property rights. What is trademark? What will come under copyright? What will come under patent? What will come under design? So for the copyright, software can be copyrighted, user manuals, ringtones, startup tones, images. Please click next, click. Yes, and patents, what can be patented? Data processing methods, operating systems, operation of user interface. Next, click please. Yes, and for overall font, the appearance and or the shape of the product can be protected under design protection. So these are the features of intellectual property. Next, please. Yes. So types of intellectual property: patents, trademarks, copyright, designs, geographical indications, plant varieties, and semiconductor designs. Next, please. Comparison of types of intellectual property rights. What types of comparisons? First of all, basically patent is given for the invention only, and words, phrase, logo used as trademarks on the goods or a service is protected under trademark law, and original literary, dramatic work, musical and artistic work, cinematographic film, sound recordings will be covered under copyright. And what is the come under a geographical indication? Identification of goods or services from a geographical source of origin will protect under the geographical indications. And shape, configuration, pattern, ornamental, etc. applied to the article and judged by the looks or appeal to the eye will protect under the design. So how to protect? File application for grant of patent. We can file the application for the patent, and we can file the trademark application with the registry. We can file for the copyright application with the copyright registry. So these are the process for the protect for other aspects. Who can apply for registration? Inventors and user or proprietors, first author or assignee. And association of persons or producers can be protected under geographical indications. And what is the test for protection? It is very important feature. What is the test for protection? Test for protection means when we go for a patent, there are three criteria: novelty, inventive step, and commercial viability or economic significance. And secondly, for the trademark, it should be distinctiveness from the other's product, and it should be non-similar or deceptively similar to the other products. And what comes under the copyright? It should be original. Original work will be covered under copyright. Source of geographical origin like Bikaneri Bhujia, it will cover under geographical indications. And designs, it should be new and original. Next, please. Yes. Next, please. Yeah. What is the term of protection? The 20 years from the patent from the date of filing, and 10 years for the trademark initially, and it can be renewable indefinitely every 10 years, and copyright over 60 years after the death of the author, and 10 years initially renewable indefinitely for geographical indications, and designs 10 years initially, and it can be extendable by 5 years also. So these are the comparison, we can say these are type of intellectual property rights. Right to exclude of how protection provided, right to exclude other from making, using, selling, offering to sale and importing, right to exclude other whose use may cause confusion or deception. It will come under trademark. And copyright, right to prevent unauthorized copyright or public performance, exclusive right to the use of GI in the relation to those goods, and powers to exclude others to use or apply registered design. Next, please.
Please continue.
So, what can I protect with, what can I protect with a patent? What patent is for any invention or any product or any process, which may be composition of a matter, which may be machines, which may be manufacturing method. But what about the software? Software is a patentable subject matter or not? So software basically is not patentable subject, because software per se or mere software is not patentable under the patent law. So how can we protect the software? Yes, with the help of the embedded system connecting to the software, we can get the patent itself. So I cannot protect with a patent. What can I not under patent? Ideas, only obvious things, combination of prior arts, illegal or immoral matters, pure research, novelty or curiosity. So these type of concept are not covered under patent, because mere idea cannot be protected as a patent. Like you can take the example of time machine. Time machine is only mere idea. It's a very good idea. It's a very good thought, but it's a mere idea. It cannot be executed on the actual, on the original basis. So basically ideas cannot be go for a patent. Next, please. So what precautions should we keep in mind at the time of filing of the patent application? What should be disclosed? The publication, article in a journal or a newspaper. We should not flyer, abstract, preprint, websites, blogs, internet postings, letter, fax, emails, discussion with friends, public use or offering for sale. Discussions inside the company in a lab, non-disclosure, it should be covered under non-disclosure agreement. Letters, faxes, emails, discussions, seminars, if they are explicitly covered by a non-disclosure agreement, then otherwise we should not disclose our invention before the filing of patent application. Next, please. Yes. So what do I, if idea comes in my mind, at the time of conceive of any idea, we should write down on a paper, and we should keep the details in the notes wise, and try to convert your idea into practice, because executable of any idea should be very first condition of getting a patent, because it should be novel and it should be commercialized, because if the patent is not having economic significance, it will not be granted. So these are some technical aspects which should keep in mind at the time of writing the patent. So next, please. So what is the patent system? So patent gives the exclusive right to the patentee of a product process to prevent third parties who do not have his consent from making, using, offering for sale, selling or importing for those purpose that product or the products produced by patented process. Because if we reveal our invention or disclose our invention to the government, in the exchange of disclosure of this invention, government gives the monopoly right to the patentee or to the inventor or the applicant. Next, please. So sometime it may call it is the adverse view of the patent system, like because patent creates monopoly and monopoly kills the competition, and killing competitions hampers the economic growth. Therefore, patent should not be granted. Like this, patent should not be granted because it is an adverse view. No, because next please. It is benefit to the public. It is not the harmful for any public, because motivation to research and invention to the inventor or the applicant, because we can say the patent is the award for the inventor and reward for the investor. Provides incentive to inventor to disclose his invention to the general public instead of keeping it state secret. Commercial reward for converting inventive ideas into vendible useful products, and provides incentive to invest capital to develop new products. So next please. Yes. So what is the scenario between the employee and employer? Because all rights goes to the employer or company or university, and in the exchange of all rights, the inventor may get or employee may get the extra benefit or extra motivation to get the new IP rights. So patentability. So there are three criteria I have already discussed: the novelty, non-obviousness, and industrial utility. Novelty means it should be novel throughout the word. It should be novel throughout the word means it should not disclose or it should not anticipated in any manner, in any kind throughout the word, across the word. It should be novel. And second is non-obviousness. Non-obviousness means it should be having technical skills, involved in technical skills, and must be having technical features in the particular product or process. And industrial utility means it should be having commercial viability. So there are three criteria for getting a patent. Next please. Next please. Yes. So when the invention is new, how can we decide our invention is novel? So when it is not part of the state of art, so you can see there are two pictures of kettle. One is for one spout, and in the right side there are two spouts in the kettle. So you can see from the date of filing, it will cover under the state of the art, means prior of the art. But after the date of filing, or on or after the date of filing, it will go for a new invention. So next please. So you can see here what was the prior art: teapot with one spout. And what was the drawback of prior art? It was time consuming. And what problem to be solved? Reduce filling time for multiple cups. And solution: provide a second spout. So you can see here, it's a very small invention, but it will change it will solve the problem. So it will solve the problem with the time consuming. So advantage of the invention: filling time is reduced. So what? Okay, it's okay. Please next. What exactly can be patented? Chemical substances, processes, methods, uses, products, device. These will cover under patent, like for new inventive step and industrial applications. Next please, click. And next please. And in India, patents are not granted for business methods or rules or games as such, or methods or treatment diagnostic and surgery on the human or antibody. So sometime if we have our invention having novelty, inventive step and economic significance, but the Indian patent law does not give the does not provide the patentable right, because there are some provisions which will cover as these are not an invention under section 3 of the Indian Patent Act, like an invention which is frivolous, or which claim anything obviously contrary to well-established natural laws. An invention, the primary or intended use or commercially exploitation of which could be contrary public order or morality, or which causes serious prejudice to human, like the mere discovery of a new scientific principle or the formulation of an abstract theory like Newton's principle or Archimedes' principle. So it will not cover under Patented Act. Next, please. The mere discovery of a new form for a substance, like if you take the example of aspirin. Aspirin was used in the headache before, but nowadays it is used in the cardiac diseases or blood thinner, as a blood thinner, but it is a mere new use. It is not a new product. So we cannot get the patent or monopoly right on the new use of any known products. Next, please. Yes, a substance obtained by a mere admixture resulting only in the aggregation of the properties of the components thereof, or a process for producing such substance, the mere arrangement or rearrangement or duplication of known devices, each functioning independently of known another in a known way. So mere arrangement of a known rearrangement or arrangement of a known device is not patentable subject matter. Next, please. A method of agriculture or horticulture cannot covered under patent. Any process for the medicinal, diagnostic, surgical, curative, prophylactic, or therapeutic, or method of operation or surgery cannot covered under Patented Act as per the section 3I of the Indian Patent Act. Plants and animals in whole or any part thereof other than microorganisms, but including seeds, varieties and species, and essentially biological process for production or propagation of plants and animals, also not covered under patented. A mathematical or business method or a computer program. So you can see the as per the section 3K, computer program per se means if it is a pure computer program, it will not cover under the Patent Act. Next, a literary, dramatic, musical or artistic work or any other aesthetic creation whatsoever, including cinematographic works and television productions like literary, dramatic, musical or artistic work, will cover under copyright, not cover under patent. A mere scheme or a rule or method of performing mental act or method of playing game, a presentation of information. So these are the some provisions which are not covered under the Patent Act. Topography of integrated circuit and traditional knowledge like Dadi Ma ke nuske. So it will not cover under Patented Act. Next, please. Next. Yes. So who can file the patent application? Application may be made by the first inventor either alone or jointly with another or their assignee, legal assignee, legal representative of deceased inventor or assignee. Means the first or true inventor can file the patent application or their assignee can file the patent application. Next, please. You can see the fee structure of the patent filing. Rupees 1600 for natural person, for individuals, MSMEs and startups, and other than natural person it is 8,000 rupees, and it will limit to the 30 sheets and 10 claims. After 30 sheets, it will cost additional cost 160 rupees per sheets and 800 rupees per sheets for other than natural person. Next, please. So what are the elements of invention at the time of filing? Title, technical field, background of related art, summary of invention, object of invention, brief description of the drawings, detailed description of the invention, claims. Claims is the techno-legal part. Is a statement of technical facts expressed in a legal term defining the scope of the invention. Should to be protected. Drawings, sequence listing, if any, and abstract. So these are the main elements to file the patent application. So what are the prosecution steps of patent application? First of all, if we file the patent application at the patent office will issue the filing number and date that this is the application number. And after the filing of application, patent office will publish this application after 18 months in the official journal of the patent office. And after the publication, applicant has to file request for examination with the patent office within 4 years from the date of filing. If they not file the request for examination, this application will be lapsed. So this is very strict deadline. Everybody has to follow this deadline. Pre-grant opposition, like if we tell about the this application has been filed, and if anybody have any objection before the grant of opposition, before the grant of any application or patent, anybody can file pre-grant opposition. There is no fee for pre-grant opposition. And after the getting request for examination, patent office will technically examine your application and will issue the first examination report. It is called FER, first examination report or first office action. And after the getting first examination report, applicant has to give the reply of the first examination report to the patent office within 6 months, or it can be extended up to 3 months extra. So within 9 months, you have to file the reply of the first examination report. If you don't file the reply to first examination report, your application will be lapsed. And after the getting review of your reply, the patent office will decide whether it should be granted or not. If they have any objection, still any objection, so they can issue the hearing, and after the opportunity of being heard, patent office will allow this application and grant the patent number. After the granting, patentee has to file every year renewal fees, and it will publish in the publication of the grant in the official journal. And after the grant, any person, interested person, can file the post-grant opposition whether this patent should not be granted in many causes. So general procedure, I have already, next please. Yeah, general procedure, filing of patent application already discussed, and publication after 18 months. Yes, if anybody have any, if anybody wants to publish their application, early publication, so they can file the request for early publication to the patent office, and patent office will publish this application within a month. And after the publication, anybody can file the pre-grant opposition, as I have already discussed. Next step is request for examination, grant or refusal, publication of grant or patent, post-grant opposition, and decision by the controller. So these are the general procedure for obtaining a patent. Next please. Yes. Renewal fees up to 6 years. It is 800 per year for individual and 4,000 per year for other than individual. 7 to 10 years, it is 2,400 per year for individuals, 12,000 per year for other than individual. 11 to 15 years, 4,800 per year for individuals and 24,000 for other than natural, and 16 to 20 years rupees 8,000 per year and 40,000 per year for other than natural person. So recent trends. What is the recent trends? This is the main website of the Indian Patent Office. Here you can search what patent has been, what applications has been filed before the patent office, and how many applications have been granted in this week. So every time, this is the real-time basis website of the Indian Patent Office. Next, please. Yes, you can see the trends in patent application. As per the, you can see that 2014 to 15, there were 42,763 applications were filed, and as per the last record 2018 to 19 of the annual report of the Indian Patent Office, these were filed 50,659, and 22,631 applications were filed examined in 2014 to 15, and you can see the increment of the examination application. In the 2014-15, it was 22,131, and in 2018 and 19, it was 85,426, and if you see the number of granted patent, 5,978 granted in 2014 and 15, and almost 3 times you can see 15,283 applications were granted in 2018-19. So during this year, the number of patent applications examined considerably increased as compared to the number of applications examined in the previous year. Domestic filing of patents application has to increase to 33.6% as compared to 32.5% in 2017 to 18. Next, please. So application filed by Indian applicants state-wise, you can see as per the annual report of the Indian Patent Office, you can see the application 4,197 applications were filed from the state of Maharashtra, and least 109 applications filed from Assam. So these are statistics as a state-wise. You can see. Next, please. Yes, the top 5 Indian applicants for patents in the field of information technology. For information technology, you can see these are top 5 Indian applicants. First one is Tata Consultancy, and on the 5 Indian Institute of Technology, IIT collectively. So these 5 applicants were in top 5 in 2018-19. Top 10 Indian applicants for patents from academic institutes and university. First one is like Indian Institute of Technology collectively, Chandigarh University, Shulin University, MIT University. So these are some top Indian applicants, academic institutions, which were top 10 applicants in the year 2018 to 19. So what next, please? What issues faced by academic institutions after getting a patent or at the time of prosecution or before the filing of patent? What are the issues which were faced by academic institution, like prior art searching? First of all, it is prior art searching. For filing any patent or for grant of any patent, your application or your invention should be novel. So prior art searching is a very challenging task. Literature survey, prosecutions like strict deadlines. You have to file request for examination within 48 months, and you have to file the reply within 6 months from the date of FER, and other also deadlines. There are so much deadlines. So these are challenges which will force to the academic institution. Annuity fees in every year, and working of patents like Form 27 is very crucial for after the grant of patent. Technology transfer, how can it be technology transfer to the commercialization and exemptions for research. Next, please. So you can see the searching for patent can be easy, but some basic knowledge is needed. You can see this is the spring. You can say it is spring, but in the patent database, you cannot find as the term spring. It is energy storing means. So you have to have some basic knowledge of patent, like some synonyms, or you can say the some technical words, like it is not a spring, it is energy storing means. Next, please. Next, please, sir. Yeah, it is transistor. You can see the transistor, but in the patent term, it is called semiconductor switching device with a control electrode. So if you search with the jargon a transistor, it will not come under the prior art. Next, yes. So this is toy ball. Basically, this is toy ball, but sometimes the applicant simply doesn't want his patent to be found. Spherical object with floppy filament. So you can see the difference between the general words and patented word and terminology. Next, working of patents. Yes. So after the getting of patent, every patentee should be filed the patent, whether this patent has been worked or not in India. Information required in case patent is worked in India. So what revenues has been generated from this patent, and who has to file. Every patentee and licensee, irrespective of the nature of license held, would have to furnish the statement. Joint holders of a patent, be it natural person or legal entity, can file a single patent, single statement. Like everybody has to file, every patentee has the obligation to file the working of patents, White Form 27. So you can see the aspect of technology transfer, because there are so many lengthy processes when the idea conceptualized or conceived in your mind, and you should have filed the patent application, and after the prosecution and granting the process, you should have an feasibility analysis, resources, manufacturing, financial management, because financial management is a very crucial point, human resource management, networks, marketing. So after marketing, you can get the commercial viability of your patented product. Next, please. So this is the type of patent certificate after getting the patent office issue this type of certificate to the patentee. And if you, next please. Next please, sir. Yes. If you can see the software breakthrough invention, IBM, through IBM, the USPTO has been granted to the IBM company US 4965765. The patent number is that fat lines to turn a thin line on a computer screen into a broad line. Microsoft got the patent White US 7415666, page up, page down technology, and on the double clicking also White 6727830. And Apple has also got the patent automatic software update and slide to unlock. If you have iPhone, so you can see there is a slide to unlock. It is a patented technology of Apple. And Intel digital video recording, European patent has been granted 1254562. And pop-up windows, if you see the pop-up windows, it is also software patented, got the patent by Intel. Alcatel, you said, US 56279378, MP3 technology, for the MP3 technology. And if you can see the name of Somasundaram Ram Kumar, it is a Indian person. The Indian patent was granted 214388 for a dual SIM phone. So basically nowadays dual SIM phone is a very common feature of the phone. Some interesting patents were granted at the early era of the patenting system. मुस्टेज गार्ड कहते हैं ना, मूछ है तो मूछों की शान है, तो उसको प्रोटेस्ट करने के लिए एक मुस्टेज गार्ड, व्हाट इज द ट्रेडिशनल सिंबल ऑफ ट्रू जेंटलमैन इफ नॉट मुस्टेज. सो दिस इज पेटेंट वाज ग्रांटेड in the 1876 by the US Patent Office. Next, please. This patent was granted for a bicycle. If you can see the early era of bicycle, yes, this is bicycle. The bicycle patent by Louis S. Weinberg in 1900 century allows you to exercise both your legs and arms while cycling. The object of the invention is to provide means whereby one may enjoy with a bicycle exercise like that of rowing with a pair of sculls. The patent explains looks fun with what we are not sure how the brakes work. So you can see other patented invention like traffic signals. It is also patented technology. Radio. Next, please. Next, please. Yes. Radio is a very important invention. Camera in stumps. You can see the camera in stumps because camera were already existed and stumps are already existed. But at the time of doubt of umpire, you can see the actual real-time basis the image whether batsman out or not. So paper clip. This clip was originally intended primarily for attaching ticket to the fabrics. You can see, next please, sir. Yeah, you can see the paper clip. If you unfold this paper clip, it is a simple piece of wire, nothing else. So, but it is, if you fold it in a particular manner, so it is a patented product. So this patent was granted in 1867 by patent number 64088 by the US Patent Office. So you can see that every small invention has a prospect to get the patent. Locks, in ancient times you can see these types of locks were available. Next please. Next please, sir. Yes, you can see the guns and pistols, revolutions of the guns, you can see from the top and the bottom. Pressure cookers, you can see the ancient times of pressure cookers and the modern times. So it is the evolutions of inventions. Next, please. Next, please. Yes, you can see the refrigerator and the difference. So journey of refrigerator you can see. Next, please. Next, please. Yes, typewriters. You can see the typewriters, vacuum cleaners. So you can see easily, you can identify the patented product or you can see the identify the invention, because if you heard the necessity is the mother of invention, every time everyone can file the patent for his technology, because every single, like I have given example of paper clip. If you see this paper clip, if you unfold the paper clip, it's a piece of wire, nothing else. But it is a very important aspect. Yes, you can see this paper clip. You can see this was very simple piece of wire. But if you fold it in a particular manner, so it is a very crucial role of particular necessity. Thank you, sir. Thank you.
Thank you so much, Advocate Ashish Sharma ji, for your valuable time, your lecture on basics of patent and what have done so far in the world and in India. You taught us a journey of 1,000 miles begins with a single step. So our faculty members, research students, and our other colleague of the nearby region may be benefited from this lecture as well. We will go to next session of Professor Dr. Vimal Anjum, Professor DAV College Chandigarh. After short time, I would like to request Dr. Nitin Thapar, Associate Professor and HOD, SOMC RIMT University, for a vote of thanks for Advocate Ashish Sharma ji. Thank you, Ashish Sharma ji. Over to you, Nitin Thapar.
A very good morning, sir, and very good morning to all the faculty, research scholars, and students who have attended this session, very valuable session. Sir, we are very thankful to you. You have given a lot of awareness about intellectual property rights. You have very well and very clearly defined the different type of intellectual properties and difference between various intellectual properties and their comparisons. You also enlightened the audience that how to protect the invention and very well explained the direct and indirect benefits of the patents and how to protect the intellectual property, and a very well explanation of the process of filing the IPRs and what are the benefits of the patents to the general public, what are the direct and indirect benefits of the patents, and you also enlightened the audience that what is included in the inventions and what is not included in the inventions, by giving a very valuable examples like Microsoft, Apples, and given a very general example of mustaches, bicycle, etc. And generated the awareness among the audience that very small things which we are using in our day-to-day life, how they are also patented. Example, paperclip, pressure cooker, etc. Thank you so much, sir, and I believe and I'm sure that this valuable session has benefited the audience a lot. Thank you so much, sir, once again.
Yes, Professor Dr. Ajay Rana ji, your hand is raised. Do you want to discuss something, sir?
Yes, sir. I have some question with Advocate Ashish Sharma ji.
Okay.
You have mentioned in your slide that is in under type of IPR, there is a plant varieties.
Plant varieties, yes.
Yes, sir. Need a basic information about this. What basically plant varieties under what IPR it is being coming?
If you heard about the basmati rice or neem patented by the US PTO, they have been granted the patent of the basmati rice, of the new variety of basmati rice. So
Okay.
these types of plant varieties or new varieties or seed varieties can be protected under PVFR, matlab plant varieties and farmers' right. Basically it will give to the particular society or particular to the society of farmers for plant variety. If you generated new seeds, न्यू वैरायटी लाइक गेहूं की अगर कोई वैरायटी है, कोई राइस की अगर नई न्यू वैरायटी है, कोई पल्सेस की, कोई फ्रूट्स की अगर नई वैरायटी है, तो यू कैन गेट द प्रोटेक्शन इन अंडर द plant variety and farmers right.
Okay, so that is being linked with some all agriculture based and anything that you have also mentioned, that is Bikaneri Bhujia, that is also being coming under plant varieties.
No. Bikaneri Bhujia is related to geographical indication. Geographical indications means which denotes to the particular region.
Okay.
Yes, Bikaneri Bhujia, Agra ka Petha, Darjeeling tea, Mysore silk. So it will cover under geographical indications.
Geographical location. Okay, thank you, sir.
Thank you, sir.
Thank you, Advocate Ashish Sharma and Professor Rana. Any other friend with us? Yes, Dr. Taranjeet Singh Vij. You can ask Dr. Taranjeet, ask any question. You are allowed to unmute.
Yes, sir. Very good morning to all of you. And
Yes.
Ashish, sir, really very interesting session on the IPR. Sir, I have some questions in my mind from your presentation. Sir, if we are filing, is there any page limit when we are having some idea? Or one more thing, there is in one slide you have asked for role of attorney. Sir, what is the role of attorney in filing? And my little more question that I want to know the difference between the Australian patent. Does it we have to file with the IPR of India also to take the Australian patent? Because on various platforms I have seen that many researchers have filed the Australian patent. Is it
Okay.
valid in India? These are my little questions.
Okay, sir. Thank you. So first of all, I would like to give answer regarding the page limit or regarding the sheet limits of any patent. There is no limitation. There is a limitation of 30 sheets within the prescribed fee, which is fixed 8,000 rupees for 30 sheets and 10 claims. If you have more than 30 pages, you can file the additional fee per 800 rupees per sheet. So there is no limitation. You can file in thousands sheet, but you have to give additional fee after the 30 sheets.
Okay, sir.
Okay. And second question is relates to the role of attorney.
Yes,
Role
sir.
of attorney is just like a role of advocate in the court for defending your case before the honorable court. Because if you don't have any knowledge regarding patent law, if you purchase a land, or if you purchase a piece of farming agriculture land, so you have to, first of all, you have to demark your land or you have to fencing your land, because nobody should trespass in our land we should not trespass in others land. So basically this is the feature, and this is the role of the patent attorney, कि जो आपको हेल्प करता है कि वो आप किसी दूसरे की इन्वेंशन को इन्फ्रिंज ना करें और कोई आपकी इन्वेंशन में कोई इन्फ्रिंज ना करे. ऐसा ना हो कि वो आपकी इन्वेंशन यूज कर पा रहा है और आप उसको इन्फ्रिंजमेंट कर ही नहीं पा रहे हैं, आप उसको इन्फ्रिंजमेंट का सूट नहीं कर पा रहे हैं, बिकॉज देयर इज अ वेरी स्ट्रिक्ट claim formation, because we have to because if we describe all the things in the description, it doesn't matter that you have protected all the description, because claim is the legal part, ki what you want to protect. So in the claim drafting or in the legal drafting or prosecution, there is a role of the patent attorney. Is it clear?
Yes, sir. Thank you very much. So explanation. So last one is left for IPR and Australian patent.
Australian patent. So first of all, you have to very clear in your mind, patents rights are territorial in nature. Territorial nature means if you file the patent in India, you will give the right for only for India. It doesn't mean that you have there is no international patent word. If you seek your patent right in Australia, so you have to file in particular country. See this patent invention as per the commercialization, not for your academic purpose. Because commercially अगर हम कहें कि ये पेटेंट हमें क्यों मिलते हैं, पेटेंट हम क्यों लेते हैं, पेटेंट हम सिर्फ उसके अपने बायोडाटा में या अपनी रिज्यूमे में बढ़ाने के लिए नहीं लेते हैं. पेटेंट इसीलिए लेते हैं कि अगर हमने कोई नई टेक्नोलॉजी है उसके ऊपर हमने काम किया है, तो कल को अगर कोई यूज करेगा तो वो हमें उसका रॉयल्टी देगा उसकी, राइट?
ठीक है.
सो सेकेंडली, इफ अगर हम ऑस्ट्रेलियन पेटेंट की बात करें, ऑस्ट्रेलियन इनोवेशन पेटेंट की बात करें, सो इट इज नॉट स्टैंडर्ड पेटेंट, इट इज इनोवेशन पेटेंट. इट इज कॉल्ड इनोवेशन पेटेंट, which is granted without examination, of any authority. Because we can give the example जुगाड़. Here we can see the utility patent. It is called also utility patent, कि अगर कोई जैसे ये शॉर्ट टर्म के लिए दिए जाते हैं, जैसे 8 years के लिए दिए जाते हैं. इंडिया में अभी ये लॉ आया नहीं है, ये काफी टाइम से पेंडिंग है, जल्दी इंडिया में भी आ जाएगा.
तो उस केस में परमिशन, सॉरी फॉर इंटरप्टिंग सर, एंड माय क्वेश्चन इज लिटिल बिट लॉन्गर आल्सो. So sir, should we apply in Indian IPR also if we are going for Australian patent? somebody
Yeah,
is going to-
yes. There is a provision under Section 39 or White Form 25. You have to take the permission first of all from Indian Patent Office because it should not be a threat to the national security.
Okay. Thank you so much, sir. Ashish sir, thank you, Kaswan sir, for arranging this beautiful lecture, and it was really knowledgeable, and it enhanced the knowledge of our faculty also, and sir, our research scholar and many.
Thank you, Dr. Tanji.
Thank you, Kaswan
Maybe
sir.
we have. Okay. Thank you. Sir.
Okay, sir, thank you.
So there's some queries from our professors and beautifully advised by Advocate Ashish Sharma ji. We are again very thankful to Advocate Ashish Sharma ji. He is the IPR consultant for various universities, academic institutions and corporates as well. Thank you once again, Advocate Ashish Sharma. Thank you so much from RIMT University.